everyone. Jax West from Stephen Avery Project, Justice with Jax, and MAM Gossip. Christopher tells me that Facebook's been having a little issue today with Facebook Lives and comments on Facebook Live. So I'm to not be surprised if no comments are able to come through today. Um, so if you try to comment and aren't able to, and there's Christopher right there. So Christopher's on. Um, and just know too, once I get to reading these, I'll be reading this on this screen, and I forgot to bring a pair of glasses up here, so um, just bear with me on that. But when I'm reading these, I may miss your comment if you're able to get a comment through. And it's not because I'm ignoring you, it's because I'm looking at this screen and may not be able to come back onto this one and catch your comment. Those of you who have been around the case for as long, or I don't know if there's anybody that could be longer. uh, so anybody who's been with the case prior to making a murder, feel free to answer any questions if you're able. I first want to talk about a post that was made on Stephen Avery Project. Hi, Carrie. On Friday. So it was in the news that my good old buddy was fired or left, or however you want to word it, the Daily Wire. And so we made a post about it. And I'm trying to fix this thing. Okay. And so we had a whole lot of people then wanting to get political, or people that are fangirls of Candace Owens, and trying to attack the page, or whatever. So let me say again, for those who may not remember or are new, we are Stephen Avery Project, and we believe that Stephen is innocent. This is not one of those pages where we're going to debate both sides of the issue. We believe that science and facts and witnesses show that Stephen is innocent. There are plenty of other pages out there. This is just Facebook. At the end of the day, big deal. It's just Facebook. So this is just the Facebook that people get mad if I use the word own, because how do you own a Facebook page? I run whatever. It's just Facebook, okay? No big whoop. And anybody can start a Facebook page. There are plenty of pages out there that believe Stephen's guilty. There are pages out there that debate guilty or innocence. Stephen Avery Project is not one of those. I am not taking away your right to free speech. You can just take it elsewhere on any of the other Facebook pages. Should I be able to go onto your personal Facebook page and disagree with you on things on your page? No. So this is my page, and these are my rules. You can think what you want and believe what you want. But when Candace Owens makes this stupid documentary claiming Stephen is guilty that aired on Daily Wire, and then she's no longer working at the Daily Wire and everything is pointing to they got rid of her, of course we're going to laugh at that. Because again, this is somebody who is saying that Stephen is guilty. So we're not saying anything about her politics. All right. This page is a non-political page. I can talk politics. I'm chief of staff for an Illinois state representative. Okay. I work in politics. So it's what I'm doing all day long is political crap. Um, but this page isn't for politics. So we made a post because somebody who made a crappy documentary that didn't give you all, it's hypocritical because they want to attack Netflix, saying that Netflix didn't show you everything. And no documentary can show you everything. There is no true crime show in the history of true crime shows that have showed you everything that's in a case. It's not possible. You have to be able to um what is the word I'm looking for? Oh my god. I have such brain things. Um you have to be able to edit it down. So you can't show everything. Just like a trial edits it down and doesn't give the jury all the evidence. Everything gets edited down. Nobody has everything. So Netflix didn't show you every aspect of the case. Convicting a murderer did not show you every aspect of the case. So, but making a murderer wasn't saying that something else was false or leaving stuff out or whatever. Making a murderer was showing you what it could show you. Convicting a murderer then wanted to pick on making a murderer, saying you didn't show us this, you didn't show us that. They never played this phone call or play this, but then that also didn't show or play those things in their entirety. Oh, Jessica, let me tell you, because, I know people get mad here when I talk about other cases, but Marnie Yang, a case that I know a lot about, that I am part of that case, and 2020 just did an episode on Marnie's case, and we gave them a ton of access to things, and so much is missing. So no matter what it is that you're watching, whether it is Netflix making a murderer or Daily Wire's convicting a murderer, they don't have everything. You have to look into these things for yourself. It's like the X-Files. The truth is out there. So for all you who are watching this and you want to start yelling at me about Candace Owens, and you're not able to do it because you have to be a follower of this page to make comments on this video, I don't care. I don't care that you're upset with us because you worship Candace Owens, and how dare we say something about somebody that you like, and then you want to make it all political. It's not. She put something out there saying Stephen Avery is guilty, and this is a page that supports his innocence. Simple as that. Leave your politics somewhere else. And you want to post that crap, again, we'll delete it. And you could get banned. So that's that. As the wedding singer says, I have a microphone and you don't. And you will listen to every word I have to say. Hi, Gina. So I just wanted to kick that off with that because it's been quite busy since that post was made on Friday, with people so upset that we said anything about her. So there it is. It's not political. Bye, Jessica. You'll have to watch this on later, huh? So I apologize that we didn't have these when they were released on Friday. Me having a stupid job now prevents me from being able to hunt this stuff down and go live immediately. So I actually didn't even get them until today. So, and I haven't read them because I like to always read them for the first time when I read them with you. So I don't know what they say. I don't go to any other pages. I don't have sock accounts and sneak on other pages. I've been told that there's a Discord group that they keep doing videos or whatever it is. I'm not on Discord. So whatever you call it on Discord that are always talking about me. Whatever. I don't go anywhere else and I don't care what anybody else has to say. I'm going by what is actually happening with the case. And so, thank you to the people who sent them to us at Stephen Avery Project, because also Kathleen Zellner tweets about this stuff when it happens, and I'm not on Twitter or X or whatever you want to call that mess. So please, in the future, if you see these anywhere that filings or something is going on, you can send it, you can message it directly to Stephen Avery Project. You can email me at either justicewithjax@gmail.com or official Stephen Avery Project at gmail.com. So here we go into the first one. I've never done the screen sharing thing. So sorry that you have to just look at my face when I read this stuff and I don't show it to you. But let me get the link before I start reading it and posting it over here for those who want to read it for themselves. This one, oh my God, is 46 pages. This is going to be, how long is Kathleen's? Kathleen's is 37 pages. So this could be a long live. All right. So this was filed on March 21. Response opposing motion to stay appeal. And to keep things quicker, I am not going to read anything rehashing the case. And also I never read when they have to compare it to another case. So so I don't read about the other cases. So okay, response opposing motion to stay appeal. This is what the state filed. The state of Wisconsin, by Assistant Attorney General Lisa E.F. Comfer, opposes Stephen A. Avery's motion to stay this appeal while he pursues new DNA testing of evidence pursuant to Wisconsin statute, whatever. A stay would be futile. Is it futile or futile? Would be futile, and the motion is inappropriate. This court should deny it. The only issue for this court's review is this appeal is whether the circuit court properly denied without holding an evidentiary hearing, alleging that he had new witness testimony, either meeting the newly discovered evidence test or sufficient to show that the state violated Brady. Talking about other cases. This court could not consider any such test result, quote, for blank use in determining whether unquote, whether the circuit court properly denied Avery's Wisconsin statute, whatever motion, because no such results were presented to the trial court in that motion. Avery has not even attempted to explain how any new DNA evidence he develops now could be relevant to whether the circuit court properly denied his third Wisconsin statute motion, in which no DNA evidence was presented. A stay and remand for Avery to pursue a Wisconsin statute whatever motion would also be inappropriate under this case's current procedural posture. A Wisconsin statute whatever motion is an entirely separate action from a Wisconsin statute. So it's 974.07 is different than a 974.06 motion. It has its own set of procedural requirements and remedies, and appeal from denial of such a motion may be taken, quote, as from a final judgment, unquote. whether Avery can meet the requirements for DNA testing under Wisconsin Statute .07 is not at all germane to whether the circuit court properly denied with Avery's third, the '06 one. Hi, sexy girlfriend. As insufficiently pled. It was just my sexy girlfriend Miley's birthday last week. Or newly discovered evidence claim based on purported new witness testimony. Avery's latest motion is really just an attempt to conflate a separate proceeding under Wisconsin statute, the .07, with Avery's current proceeding under statute 06 for the purposes of delay. This is not viable under Wisconsin law. Pause. It's not about delay. It's about, I filed, here's what we got. But now it's, hey, wait, I want the RAV4. So, and the way our dumb courts work is, well, since you've already filed this, we're not going to let you now put this on too. So, you need to pause this or you need to dismiss this to only talk about that. But again, our court should be about justice. And you shouldn't be afraid of new evidence and letting it be heard. A stay and remand is not necessary for Avery to raise any issues related to any DNA evidence and would unduly prolong this proceeding. If a stay pending a .07 motion were to be granted, this appeal would languish for years. Oh, because, trials never go for years, right? Would languish for years, regardless of whether the motion is successful. For example, if the circuit court denies the motion, either before or after DNA testing, undoubtedly Avery would seek to appeal that, the word that is italicized, that ruling, creating a procedural morass if this appeal is still pending, considering that Wisconsin Statute 07 has its own post-conviction and appellate procedure requirements. On the other hand, if the circuit court permits Avery to conduct new DNA testing, this appeal could not continue until that testing was completed, evaluated, and the Wisconsin Statute 07 motion finally determined. But to pursue additional claims not encompassed by 07, i.e. the constitutional claims already raised in his 06 motion, Avery must meet either the newly discovered evidence test or show a sufficient reason why he could not have performed this testing prior to any of the rest of his voluminous post-conviction litigation. Otherwise, any arguments he could make about the results are procedurally barred. I wonder why he couldn't do any tests on the RAV4 in all these years that he's been sitting in prison for something he didn't do. I wonder why they couldn't test the bones that were found in the gravel pit. Assuming Avery could make either showing, a remand would be superfluous. Big words. No new DNA test results could possibly affect the propriety of the circuit court's denial of Avery's third 06 motion, in which they were not presented, or any new non-07 claims somehow prompted by the test results could be raised in a fourth 06 motion. Avery's remedy, if he is not prepared to proceed with the relevant issues on appeal, is to voluntarily dismiss the appeal. He may then file an 07 motion and or a new 06 motion after any testing he conducts is complete. Basic procedure and fundamental fairness establish that a motion that has already been denied cannot be continuously supplemented in an attempt to repair flaws underlying it. And now they're talking about another case. The posture of this case presents a distinctly different scenario than when this court permitted remands in Avery's previous appeal to allow him to add claims for which he already had the evidence he wished to submit in hand. The present motion is an attempt to belatedly bolster his already denied motion with evidence that could have been sought earlier and isn't at all related to the issues raised in it, and it is based on pure speculation any new DNA evidence even exists. So then why do you try to cover it up? Quote, oh wait, that's from another case. Okay. Avery has ignored and attempted to circumvent Wisconsin's various procedural requirements every step of the way. He has repeatedly filed motions under the wrong procedure, along with improper attempted amendments and requests for remands and supplementation after his litany of rushed motions containing half-investigated, factually unsupported claims are denied. I can't wait to see what Kathleen says. Neither the state, the victims, the circuit court, nor this court should have to countenance this behavior any longer, particularly where the victim's interests against delay of the present appeal and in the finality of Avery's conviction are of constitutional dimension. Avery's appeal is from the denial of his third Wisconsin Statute 06 motion on the grounds that his claims that a new witness amounted to either newly discovered evidence or a Brady violation were insufficiently pled and refuted by the record. If he wants to pursue new DNA evidence under Wisconsin Statute 07, he may either dismiss his current appeal or wait until it is concluded, and then follow the appropriate procedures for doing so. But nothing new he pursues now is relevant to his current appeal. His motion should be denied. Dated this 21st day of March 2024. Respectfully submitted, Joshua Call, Attorney General of Wisconsin, and electronically signed by Lisa E.F. Comfer, the Assistant Attorney General. And my husband's pulling in, so my dogs are barking. All right, so the rest of this is just Kathleen's filing, so I don't need to read any of that. I'm just scanning through all the rest of these pages to make sure. Yeah, here's Carl Reich's affidavit and his thing. Okay, so none of the rest of this I need to read. So now we're going to go to Kathleen's response that I'm pasting that link in here so you all can read that. This was filed on March 22nd, 2024. There are 37 pages in here, but again, anything that's just rehashing stuff that's already been filed, I'm not going to read it. We're just going through what is current. Mr. Avery's reply to state's response in opposition to Mr. Avery's motion to stay appeal pending disposition of Mr. Avery's amended second motion for post-conviction scientific testing. The defendant appellant, Stephen A. Avery, by his undersigned attorneys, Kathleen T. Zelder and and Stephen G. Richards, replies to the state's motion in opposition to Mr. Avery's motion, pursuant to Wisconsin statute whatever, to stay his appeal pending disposition of Mr. Avery's amended second motion for post-conviction scientific testing by the circuit court as follows. 1. The decision to remand is left to this court's discretion. See Wisconsin statute whatever. Mr. Avery has filed several motions to supplement and remand with the appellate court. 2. The state blames Mr. Avery for the previous motions to supplement and remand, but the record illustrates that Mr. Avery's motions to supplement and remand were the result of the state withholding evidence from Mr. Avery's counsel. In 2017, Mr. Avery filed his first appeal from the Circuit Court's October 2017 and November 2017 orders denying his June 2017 motion. In May 2018, Avery moved this court directly, quote, to supplement the record on appeal with a CD disclosed to defendant for the first time on April 17, 2018, unquote. This court remanded the case to enable Mr. Avery to, quote, file an appropriate supplemental post-conviction motion in the circuit court within 30 days of the date of this order, unquote. In January of 2019, Mr. Avery again moved this court directly to stay the appeal and remand for the circuit court's consideration of specific claims related to the state's release to the Halbach family of suspected bone fragments. Again, Mr. Avery demonstrated that his prior counsel had not been informed by the state of the release of the bones to the Halbach family. Again, this court granted Mr. Avery's remand motion. 4. The current appeal pending before this court concerns an alleged Brady violation that Mr. Avery brought to this court's attention on April 12, 2021, with a motion to stay his appeal and remand for an evaluation of this claim. Specifically, the claim involves an affidavit of Thomas Sawinski, a Manitowoc motor route driver, who attests that while on his paper route in the early morning hours, days after Halbach's disappearance, he spotted a shirtless Bobby Dassey and an older man pushing Halbach's vehicle down Avery Road towards the junkyard. Sawinski further attests that after delivering the paper, Dassey attempted to block his exit and thus caused him to swerve and drive into a shallow ditch. Sawinski claimed to have called the sheriff's office to report what he had seen, but he was told the sheriff's office already knew who did it. This court decided to deny the motion to remand because it had already decided the legal and factual basis for the other claims raised. This court concluded that this new claim raised a distinct issue that the circuit court should resolve on a standard basis through a new Wisconsin Statute 06 motion. 5. Although the circuit court did deny Mr. Avery's request for an evidentiary hearing on August 22, 2023, it did find that, quote, the Sawinski affidavit was discovered by the counsel after the defendant's conviction, satisfying the first requirement of the Edmonds test, unquote. 6. The circuit court also found that the defendant was not negligent in seeking out the Sawinski evidence and therefore had satisfied the second prong of Edmonds. 7. This court has expressed a desire to include all possible issues in order to avoid multiple appeals. Because this court allowed Mr. Avery prior requests for remands, this court has decided one appeal on July 28, 2021, which contained multiple issues. 8. Mr. Avery agrees with the state that the narrow issue before this court on Mr. Avery's current appeal is whether Mr. Avery is entitled to an evidentiary hearing. However, the circuit court determined that Bobby Dassey's possession of Ms. Halbach's vehicle after her disappearance was immaterial and could be because, quote, Bobby was trying to hide evidence to protect two individuals directly linked by forensic evidence to this murder and convicted of this crime, unquote. The circuit court's explanation is factually incorrect. Brendan Dassey was never linked to the crime by forensic evidence. Furthermore, Mr. Avery's defense counsel did not expect such an illogical, factually flawed finding by the circuit court, so touch DNA testing was not deemed necessary by defense counsel. Moreover, defense counsel did not have the financial resources to do such testing when the circuit court issued its ruling on August 22, 2023. The touch DNA testing may confirm that the shirtless Bobby Dassey has left DNA in parts of the vehicle that implicate him in planting evidence and inflicting injuries on Ms. Halbach. Specifically, if Bobby Dassey's touch DNA is in the 5 areas of the RAV4 where Mr. Avery's blood was found, this implicates Bobby in planting evidence. And if his touch DNA is found in the rear cargo area where Ms. Halbach's blood was found, this implicates him in her assault and murder. Suspiciously, none of Mr. Avery's DNA was mixed with Ms. Halbach's blood in the rear cargo area, despite the fact the state claims Mr. Avery cut his finger while struggling with her. Mr. Avery has always maintained the cut on his finger occurred prior to Ms. Halbach's disappearance. Additionally, touch DNA testing may also implicate unknown individuals or further strengthen the state's case against Mr. Avery. What is going on here? Sorry, squirrel. 9. The state gives Mr. Avery a choice of dismissing his current appeal or waiting to file his DNA motion until this appeal has concluded. Contrary to the state's claim that Mr. Avery could have conducted the testing previously, Mr. Avery's pro bono counsel did not have the finances to do so, nor did Mr. Avery's counsel believe the circuit court would find Bobby's possession of the car immaterial because he could have been trying to help his uncle by hiding the vehicle on the Avery property. 10. Mr. Avery is not delaying this appeal. His brief is filed. It is the state who just asked for an extension until April 15 to file its brief. Mr. Avery filed a motion to stay and remand, as he did when a pro se appeal was pending in 2016, and he wished to do scientific testing. The state agreed to that testing. Mr. Avery has no intention of withdrawing his appeal, nor foregoing his DNA motion with the circuit court. 11. Wherefore, Mr. Avery requests that this court stay his current appeal and remand the case to the circuit court for consideration of his amended second motion for scientific testing before the circuit court. Respectfully submitted, Kathleen T. Zellner and Stephen Richards. What is this? All right, so this is by the court. It's signed by Angela Sukowitz on August 22nd, 2023. And so this was her decision from back then. We're not going to read through it again because, like I said, we're not going to rehash things, but you can go and read that all for yourself if you would like. I'm scrolling through it to see anything else. And you can find here in our videos where I would have read that previously if you want to. So this ends, for the reasons set forth above, the motion of the defendant is denied. So there you go. That's where we are now. The state doesn't get to respond again. I believe it's Kathleen gets the final word on this. So now we wait for the judge. And that's it, y'all. I just never understand why judges, district attorneys, prosecution, whatever you want to call it, are so quick to, no, we don't want to bring these facts forward. This evidence, these witnesses. Why won't it just go to court? And, you know, it's the court that wastes so much freaking time and costs so much money. Because the Marnie Yang case that we just had court, what was that, 2 weeks ago for Marnie, that we finally got an evidentiary hearing. But we've been, I mean, her case has been years, but it's been months of we would go to court to just be told it's getting kicked down, and then there'll be a new date. So now, when we went to court 2 weeks ago in Marnie's case, it was okay, the judge now is finally saying we can have an evidentiary hearing, and then set a new date for I don't it's a day this week, Monday, Tuesday, or Wednesday, but it's a date for just the prosecution and the defense attorney and the judge to go in there, where they're going to then discuss the date to start the evidentiary hearing. So, you just ordered 2 weeks ago that you're going to get an evidentiary hearing, and instead of just scheduling it, you have to schedule something for 2 weeks later. So now let's talk about a date, to schedule a date, which will be months away. It could be fall, winter, whatever. They're going to kick it way far down. And so you want to accuse Stephen of trying to draw things out when he's the one sitting in prison? That's just so laughable to me and ridiculous. Just crazy. Crazy, crazy, crazy. So here at Steven Avery Project, as soon as we get the filing, and once again, I can't go live right away anymore because I'm at work. I work 9:30 to 4:30 unless I'm also doing an event at night. So that's why I typically go live. It's 5:15 my time. I get home at 5 o'clock. So I get home, start the computer, here we go. So if you get it, you don't see it posted here. If you get it, send it to us, and then we'll go live. Christopher tries to give you a heads up if he can, and then there's other times that I'm just going to go live. Oh, no problem, Miley. I am well. Thank you. So whenever the judge now rules on this, we'll go live when we can. So, in the meantime, stay tuned here on Steven Avery Project. We also have the closed group MAM Gossip that's got a whole bunch of stuff in it. You can dive into our old videos, where, because this page has existed. It started like 3 days after Making a Murderer came out in December of 2016. So, there's a lot in our archives here. For those of you new to the case, interviews I've done. So there you have it. Where is it? I don't know where it is. Here's my book. I always have to give a plug before I leave for my book, Wrongfully Abused: Making an Advocate for Steven Avery by Jax West, that I self-published on Amazon. So that is about my experience with the case and things that I know that other people don't, and what Steven Avery's family has done to me in my time here advocating for Steven Avery. Because, Steven's family, many of his family, not all, not his parents, want Steven to stay where he is. Yet, they like to profit off of supporters. So, and that's just not me. I'm not going to fawn over his family just because they're related to him. These are people that are keeping Steven and Brendan in prison and are defending and protecting the real killer/killers. So there you have it. All right, I'm going to go have dinner, and we will talk whenever the judge rules or anything else pops up with the case or any drama unfolds and I want to go talk about it. So thank you everybody for joining me again. As always, investigation continues.